everybody, welcome to Learn with Steph. This is one of the videos as part of our Lessons in Law series. The focus is on OCR A Level Law, but it will be useful to anybody studying law. If you like the videos, please do subscribe and press the like button at the bottom. Hello, thank you for tuning in. This is the second video on human rights. So in our first, we looked at what human rights are, and we looked at the three different rights that are laid down in the European Convention of Human Rights. So absolute, limited and qualified rights. So absolute rights are those that can't be restricted by the state. Limited rights can be restricted, but only under the provisions of the right itself, or if the state derogates. And qualified rights can be restricted in a democratic society if necessary, but only in accordance with law and to meet a legitimate aim. And any restriction must be proportionate. So that means there must be a balance between the individual rights and those of the community. This video is all about the Human Rights Act 1998. So you need to know the key provisions in it, and you need to be able to evaluate it. Just to put it in context, before the Human Rights Act was passed, we were protected in the UK by the European Convention of Human Rights because the UK signed up to that in the 50s. But UK courts were not bound by the European Convention, and we couldn't gain direct access to the rights under the Convention. We had to take any issues to the European Court of Human Rights, which was costly and time-consuming. And any claim we wanted to make within our courts had to be made through the domestic law, and that didn't cover all the rights. So we could make a claim perhaps under EU law, for example, looking at the EU laws on discrimination perhaps, or common law, such as using Bushell's case, that famous case about the Quakers, which laid down jury independence, or perhaps looking at one of our historical statutes, such as the Magna Carta, which gave us the right against unlawful imprisonment, or perhaps the Bill of Rights, which gave us initial freedoms of speech, or laid it down anyway. So in 1998, New Labour passed the Human Rights Act. It was a manifesto promise, and they promised to bring human rights home. And the aim was to incorporate the convention into our domestic law. So basically, the Human Rights Act provided a codified document within our UK human rights law. It brought UK law within the remit of European Convention of Human Rights law. And it enabled citizens to gain direct access to the convention rights within our courts. And we'll look in a moment on how that worked. Now, just a little word on entrenchment. So, as you know, one parliament cannot bind another. So none of our UK laws, none of our acts of parliament are, if you like, entrenched. People used to argue that the European Communities Act was entrenched and we couldn't come out of Europe. Well, we know that's not the case, don't we? So in theory, the Human Rights Act is not entrenched. However, if Parliament wanted to repeal it, the devolved nations would need to agree to this in their assemblies or their parliaments. So to repeal the Human Rights Act would actually be very difficult. You need to know several of the sections of the Human Rights Act. Now, the first three on screen here are ones that you need to know to know how the Human Rights Act is applied within our legal system, and they'll be useful for your evaluation essay as well. So Section 2 of the Human Rights Act is about judicial precedent. What it says is that decisions of the European Court of Human Rights must be taken into account by UK courts. So if an appeal court finds a precedent is in conflict with a decision made in the European Court of Human Rights, then they need to follow the European Court of Human Rights precedent rather than their own. However, this is just for the appeal courts. A lower court will still follow domestic court precedent. Section 3 is about statutory interpretation. So when a court is interpreting legislation, they must interpret that legislation insofar as it is possible to do so in a way which is compatible with convention rights. And if they can't, they will use Section 4, which means if a court cannot interpret a piece of legislation in order to fulfill the rights under the convention, they can't change it. You know that, because we have the principle of parliamentary sovereignty. So courts cannot amend our acts of parliament. So if they can't interpret domestic legislation in a way to fulfill convention rights, all a court can do under Section 4 is to make a declaration of incompatibility. Section 6 and 7 are the most important ones for you to know. So if you don't remember any other human rights sections for your exam, then Section 6 and 7, then that's fine, okay? These are the two you really need to know. So Section 6 makes it unlawful for any public body to act in a way which is incompatible with a convention right. A public body is anybody basically carrying out a public function, and it's got a really broad definition to reflect modern society, if you like, but it includes local authorities, courts, tribunals, and public service bodies such as residential care and schools. It does not include Parliament. Parliament is not a public body. Now, Section 7 allows citizens to bring proceedings against public bodies in courts if they believe their convention rights have been breached. So it gives us direct access to challenge a public body for violation of our rights. It's the real key section of the Human Rights Act. Section 8 lays down the remedies that are available if a court finds that our rights have been breached, and there's a real range, including compensation and injunctions. And then Section 10 lays down the fast track procedure, and this relates to Section 4. So if a court has used Section 4 to make a declaration of incompatibility on an Act of Parliament, the Act doesn't have to go back to Parliament to be amended. It can be amended quickly through a statutory instrument. So clearly that means that it doesn't disrupt parliamentary business. Two other sections that you could know are Section 12 and Section 19. Section 12 is important for when you are doing questions about Article 10, freedom of expression, because Section 12 gives special importance to freedom of the press. And then Section 19 is really about when legislation is passed, and you'd really refer to this only in a human rights evaluation essay. So when a bill is being passed, a minister must declare that it is compatible with convention rights, but if it isn't, a minister can make a declaration of incompatibility. So you can see how that can be evaluated, can't you? Moving on to our evaluation, the green is the positives and the pink are the negatives. So it's always good to make sure you give a balanced argument. And if you do have an evaluation of human rights, you need to be very specific about the sections. So as a positive, an overall positive, obviously the passing of the human rights brought human rights home, as Labour put it. It gave us direct access to enforce our rights quickly within our domestic court system instead of going all the way to the European Court of Human Rights. Okay, Section 2, that's the one to do with our courts using European Court of Human Rights precedent. Well, obviously, that ensures all states signed up to the convention are consistent in their approach. The Section 3 to do with interpreting domestic legislation in the light of convention rights encourages that use of the purposive approach. So there's a bit of a link here to paper 2, Section A, lawmaking. Section 4 protects parliamentary sovereignty because judges can't overrule acts of parliament that are incompatible. All they can do is make a declaration of incompatibility, and that in turn will draw Parliament's attention to laws that perhaps need updating or changing. Section 8, the remedies section, gives that broad range of remedies available, so therefore ensuring that corrective justice is achieved. And then, of course, that fast track procedure for Section 10 saves Parliament time because they don't have to amend statutes that have had a declaration of incompatibility. It can be done through a statutory instrument and it doesn't disrupt parliamentary business. However, on the negatives, we're looking at Section 2 precedent. The lower courts still follow domestic precedent, even if that precedent is incompatible with a European court decision. So that means in order to change that, the case has to go to the appeal courts in the UK, and that of course is additional costs and time. Section 3, that phrase, insofar as it is possible, well, clearly that lessens the impact of interpreting domestic legislation in the light of convention rights. And then also on Section 3, a little bit of a question here. That phrase, as far as it is possible, does that mean UK judges feel pressurised to interpret domestic law in the light of European convention rights? Section 6, that phrase where that principle where citizens' rights are protected, public bodies can't undermine our rights. Problem is, it only refers to public bodies, and private companies are increasingly carrying out public functions and may not be covered by Section 6 of the Human Rights Act. And some argue that Section 19 could provide ministers with the means to legally violate our rights. So that's the end of this video. The next one will be on how to enforce the rights, so looking at judicial review, looking at different tribunals that are available and the domestic court system. If you've liked this video, please press the like button. Feel free to comment or ask a question, I'll get back to you, and do subscribe to my channel. Thank you for listening. That brings us to the end of this lesson in law. I hope you enjoyed it. If you did, please like it and subscribe to find more videos. Bye.